This is in the District Court of Ellis County, Kansas, case number 20DM-128, Ivy Agnew versus Roger Agnew. I have an announcement of appearances, please.
Your Honor, Ivy Agnew is appearing in person and with counsel Colton Ikenberry of Hayes, both appearing via Zoom.
Your Honor, Roger Agnew appearing pro se via Zoom.
We're set for a hearing on the contempt affidavit filed by Mr. Roger Agnew back on February 3rd of 25. We also have a counter motion for contempt filed by Miss Ivy Agnew on April 16th of 2025. I will advise the parties that currently the Odyssey system is down. I cannot pull up the case file, but I do have the affidavit of contempt filed by Mr. Agnew and the counter motion filed by Miss Agnew. And I also have available the proposed child support worksheets Mr. Ikenberry has forwarded to the court, as well as the payment record that Mr. Ikenberry has forwarded to the court. Do you have access to those, Mr. Agnew?
I do, Your Honor.
Okay. Any announcements before we get started this morning?
A brief one, Your Honor. I just saw an email from Mr. Agnew regarding the child support worksheet that I sent out last week. So I have prepared another one that looks prospectively going forward with my client's new income for her job that has not even started yet. She will be making slightly more than she was while she was living in the United States and working here. But that difference caused a $4 difference between the two child support worksheets. I just emailed those to your assistant, Your Honor, and to Mr. Agnew just prior to the hearing. I apologize, but I did not see Mr. Agnew's email until this morning.
Judge, I did forward that to you, and I believe I might be able to get you onto the Odyssey system if you would like me to, if you need that.
If it becomes necessary, I've tried several times this morning, including the alternate route they've suggested. It
Okay.
just hasn't worked.
The alternate route did work for me, so, okay.
With that, Mr. Agnew, would you like to call your first witness?
Yes, Your Honor. It's just myself. One other quick thing real fast. I don't know if we're going to be able to handle the counter motion today. At the end of the hearing last week, you informed Mr. Ikenberry to inform both yourself and myself on what, if anything, he was going to cover and address from the counter motion. I did not get any sort of communication from Mr. Ikenberry on what he planned to address in that. I don't think in terms of ethical provisions that he can argue that entire motion. There's a lot wrong there, and so I don't want to necessarily move forward on that without knowing what exactly he's going to argue or not argue inside of that motion. And so I think we have a small issue in terms of that.
Mr. Ikenberry.
Your Honor, my plan for today, since my client prepared that herself, I was simply planning to ask her questions to elicit the details and the basis for each of her allegations therein. You know, if Mr. Agnew wants more time to prepare for that, would not object to a brief continuance. This has all come together pretty quickly since our last hearing. But I would ask that we just simply reschedule everything for a week or 10 days down the road if the court is inclined to follow and grant Mr. Agnew's request.
Mr. Agnew.
I don't see an issue with continuing with everything else. I just think that the counter motion at this point is untimely without having the information as to what they're going to argue. I see a number of different issues, and if that's how he's going to handle it, I can handle that at a future date. But that's the counter motion is one that I'm not ready to handle at this point with that information. Everything else, with the exception of the new child support worksheet, which has a number of different issues on it that I can see just from briefly glancing at it, I'm able to continue with everything else. But my only concern coming into this was just not knowing what was going to be argued with the counter motion, and finding out that it's going to be everything. Well, I'd like to file a written response as well as handling some other things with that. So,
Well, with the parties, I believe you are in agreement then to continue the counter motion that was filed by Miss Ivy on April 16th. And Mr. Eichmann, it's your position that you'll go forward on her claims as filed in the counter motion?
That's correct, Your Honor.
Okay, that part will continue and reschedule. Today, let's take care of the motion for contempt filed by the plaintiff back on February 3rd. Mr. Agnew, you said you wanted to testify?
Yes, Your Honor.
Would you raise your right hand, please? You solemnly swear and or affirm that you will tell the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
I do, Your Honor.
Are you currently in the state of Kansas?
I am, Your Honor. I'm in Russell, Kansas right now.
Okay. Go ahead.
So I'm gonna stand on the pleadings that I filed, and I would like to just add a couple of things that have happened since the affidavit of contempt was filed. The big things I really want to focus on, Your Honor, is Miss Agnew's not using the children's cell phone. At the pretrial hearings for the trial in November, it was made extremely clear that that was the method of communication for the children. There was nothing about that changing when they moved to Bulgaria. I took steps to make sure that it had engaging content in which the boys and I could have in-depth conversations that were engaging for them. That way it wasn't such a burden for Miss Agnew, and it wasn't so strenuous on the children. And I used things like I had downloaded Zoom, I had downloaded Skype, so that way we had some options in case server issues would come up, but also just to engage the children in better conversations. In the course of the move, Miss Agnew reset the phone and was communicating with me about that. And of course, with the factory reset, it completely wipes everything out, and it has to be resituated and reevaluated. And that's an issue. It has made the phone unusable. It is also my understanding from the communications that I've had with Miss Agnew that she was attempting to use that phone for her own personal use as opposed for the children. I think that that's a very clear violation of the court's order. This affidavit I filed on February 2nd, February 3rd, that Monday. The following day, I attempted to make a video call with the children and got nothing. No answers from Miss Agnew. At that time, we were using Miss Agnew's messenger to do the children's video calls. Messenger is not as engaging as Skype and Zoom can be. And so it was hard to keep the children's attention and focus and engagement in those conversations. And so it made it difficult. But we were using Miss Agnew's messenger. February 3rd, I attempted to make another video call, received nothing. February 4th, received nothing. That Thursday, February 5th, again tried and received nothing. And at that point in time, I received a call from Miss Agnew's mother, stating that Miss Agnew had broken her cell phone and did not have a way to contact me. At that point in time, I went into my spam messages on Facebook Messenger and saw that Mr. There had sent me a message reaching out to contact me about the children. A couple issues with that. Obviously, Miss Agnew still had access to the internet, still had access to Messenger. Miss Agnew willfully and negligently did not communicate in a reasonable way. Miss Agnew could have logged into her Facebook on Mr. There's phone to reach out to me and contact me about the issue and say, hey, going forward, we'd like to do this, or how do you feel about this? Had some sort of options for her. The reason she was no longer using her phone was it was damaged in some way, shape, or form. The time frame I was given was sometime in April for that phone to be fixed and revitalized. The other thing with this is that if we had just been using the boys' phone as had been ordered, this would not have been an issue, because whether or not Miss Agnew has a phone and whether or not it's damaged does not become relevant when we're not using her phone to communicate with the children. I believe that it was very much willful and negligent on her part, and an emotion to circumvent the court's standing orders as they have been laid out, and so that I find an issue. You'll hear Miss Agnew testify about security issues and concerns that she and her landlord may have. The simple fact of that is that a factory reset isn't going to make a network more or less secure. There's nothing on that phone that can be hacked into and searched in any way to allow me to see anything that is any way, shape, or an issue. And so Miss Agnew stands on this, that she has to factory reset it before it can be used in the house. And I find that wanting for a standing in jurisdiction and for the situation, it's just not feasible for that to happen, and it's not going to change anything. She rose concerns about the parental controls, and quite simply put, the parental controls on the phone had been there since 22 when the phone was originally gotten for the boys, and there had been no concerns about the parental controls prior to the move. If there were concerns about the parental controls, Ms. Agnew's time to raise those concerns has come and gone. So that is not a reason to refuse to continue to deny the use of the phone at all. And then the last part that I will just want to briefly touch on, the Nintendo Switch that I had mentioned in the moving papers. I understand that was not ordered at the November trial, but the premise of the phone and the premise of the Nintendo Switch are one and the same. A little bit of background so the court's aware on the Nintendo Switch. There was a discussion between Ms. Agnew and I after the November trial, outside of a Love's gas station during an exchange with the children when she was still in Phillipsburg. And the conversation basically went back and forth about, hey, I was trying to figure out something that would be good and engaging for the children. So that way we can still, foster a relationship, build up some camaraderie, and just enjoy each other's time. And the idea had been brought up by me that I buy the children a Nintendo Switch and some games for when they're in Bulgaria. So that way on the weekends, we can still get together, we can play games together, and we can still have some additional time of connecting and building a relationship with the children. Ms. Agnew agreed to that, thought it was a wonderful idea. Ms. Agnew did not mention anything about any concerns about parental controls at that time or anything to that matter. I bought the Switch for Christmas. I had the children for Christmas Day. They were given it on Christmas Day, at which point I set up the parental controls and everything else. Miss Agnew was given the device when they returned back from Christmas, which would have been on or around December 28th. And she had the device for about a week and a half before they moved to Bulgaria. Again, at that point, no concerns about the parental controls have been brought up, or any issues with that have been discussed. I also don't understand if there had been an issue, why that issue was not brought up when the original discussion of the switch came up. Obviously, the children are still young. There needs to be some sort of parental controls, and part of that is safe locking things so that the children can't just go on and buy whatever game they want and rack up a bunch of fees. And so also there's abilities for them to get into mature rated content, even with free devices and free apps. And so there needs to be a level of safeguard there, and I think that that's completely reasonable. So Miss Agnew again didn't bring any concern up for the switch parental controls until she was in Bulgaria, having had time to present that before she had left. They go similar together. I'm not asking you to find contempt for the switch situation. Like I said, that was not a court order. However, I would ask for a ruling that she connects both devices to the internet, and that we go back to using the children's cell phone for their video calls, and she connects the Nintendo Switch to the network. The only thing they're almost one and the same, because the arguments against both of them are one and the same. It seems that Miss Agnew is much more interested in not having the connection that the court found very important between the children and I. It seems to me that she did not believe that moving to Bulgaria that I would still fight and continue to have the relationship with the children that I have always had from the beginning. And so this just feels to me and seems to me that it's very clear that she's trying to just continue to push me away, and is frustrated on her end that her ability to do that is not there. I had numerous conversations with Miss Agnew throughout the situations, which are detailed in the moving papers, and she was again very firm on these standings and unwilling to budge or have any sort of conversations about potential ways to work around things. And so I believe that the contempt is there, the willful negligence to follow the court order is there, and I would ask that you find her in contempt at this point.
Mr. Ikenberry, cross.
Thank you, Your Honor. Mr. Agnew, can you point out in any previous court order where the court said a particular device or manner had to be used for visits?
Yes, the pretrial hearing was specifically ordered that we use the children's cell phone.
So it's in writing that it had to be done in that exact manner. Give me every time something important is going on, a train comes.
Mr. Ikenberry, you're getting a echo response. I can't hear your questions.
Yeah, that's because the train decided to come by right here at this moment, Judge. Just bear with me a minute till it passes. Oh, the engine's by. Can you hear me now?
Yes, let's try again.
So, Mr. Agnew, you're saying that the court made a specific order that the video visitation had to be done on one particular cell phone.
That is correct.
What's the date of that order?
I would need to look back, but it was the only pretrial conference that we had in this matter back in September.
You stating that you are lacking in visits?
I did not say that I was lacking in any visits, with the exception of the first week of February, in which I missed 4 visits because of Miss Agnew's negligence.
You know it was because of Miss Agnew's negligence.
Miss Agnew did not communicate. So therefore, Those are Miss Agnew's actions, and therefore it is negligent on her part.
You just said you're not missing out in visits, so she must be offering you and facilitating more than the 4 visits per week that were ordered, correct?
Yeah, so very good point. The contempt was filed again in the beginning of February, when we were still required to have daily calls because the children had just moved to Bulgaria. That was supposed to taper off. It has in fact tapered off. However, Miss Agnew also at the time of January was indicating that she was not obligated to provide 4 calls during the transition. Or I'm sorry, she was not obligated to provide daily calls during the transition, only 4, which is contrary to the judge's orders. So part of the contempt hearing was, 1, ensuring that I was going to get my daily calls and they were going to get tapered off as the boys settled in, because again, this was filed in February, but also there was a time in February she failed to meet the calls. However, the key part of all of this is Miss Agnew not using the cellular device that was ordered to be used in September 23rd. I looked it up.
Agnew advised you that that phone could not be used on her personal internet at her house, correct?
That is incorrect.
Please elaborate.
Miss Agnew said she refused to use it on her personal internet because, according to her, that she would need to go through a factory reset to be able to use it. According to standard IT policies, what she is attempting to do would have no effect. And
On Mr. Agnew, wait for the objection.
He's testifying about things as an expert regarding IT. He has no idea what my client is dealing with.
Sustained. Mr. Agnew, carefully listen to the questions and answer those. You'll have a chance to testify again in what's called redirect.
yes, Your Honor.
Go ahead, Mr. Ikenberry.
Mr. Agnew, she advised you that she could not connect with that particular cell phone due to her landlord's policies. Is that not correct?
That is not correct. She indicated that she had to follow a specific set of procedures that she felt and her landlord felt were appropriate to be able to connect it. Not that it could never be connected.
The answer is yes.
No, the answer is no, that your question indicates that it would be never connected at all. The answer is no, it had to go through a certain set of procedures prior to.
So you're here asking for contempt because even though you're getting more than the 4 visits a week that you were ordered to get, it's not being done through one particular device.
Incorrect. I'm only getting the 4 calls that I was ordered to get at this point in time. I was ordered to get 7 calls at the beginning of the transition.
It was the transition.
Say that again. I didn't hear you. You broke
When
up.
was the transition you're talking about?
So the original court order was not very specific on the transition and the taper down from daily to 4 calls. So there was a bit of confusion in that in regards to, well, when does it go from 7 to 6 to 5 to 4? However, it was very clear in the court orders that on day 1, 7 daily calls. And then after a period of time in which the children were settled, it would go down to 4 calls a week.
So you're saying you're only getting 4 a week now?
That is correct.
Only 4. So 4 is actually quite often, wouldn't you agree?
No, I would not.
You mentioned that you were going to continue to fight. Is that right?
Miss Agnew has made it very difficult for me to get what I am entitled to with my children and my access. It has been a constant fight since the day of the divorce. Yes, I will continue to fight to make sure that I get my parental rights, and it's what's best for the children. They need to have a father who's there and involved and cares about them.
It's best for their parents to fight.
The fighting does not happen in front of the children.
What kind of remedy are you seeking here? Isn't everything fixed at this point?
No, everything is not fixed at this point.
Okay, so you're going to ask the court to instruct my client to use a cell phone that is apparently not able to be used, even though she is making arrangements and you are getting your court-ordered visitation.
The device is able to be used.
More questions, Your Honor?
Mr. Agnew, do you have redirect, meaning you can testify again?
Yes, Your Honor. The device is able to be used. It is Miss Agnew's decision not to use the phone. I would like to see, honestly, the witness who's saying that this is in fact not the case and this is in fact the policy. That's not how IT business practices work. It's not a safety concern or a violation, and I don't think that that's an expert testimony in any way, shape, or form. I think that that's standard understanding of IT for anyone who deals with computers and technology at a base standard level in the slightest. And like I said, the key point here is that, and I looked it up, it was September 23rd. That was the date of the pretrial hearing in which the order was for the phones to be used, or for the children's phone to be used. And that was not changed or amended in any way during the November trial date. And so it stays the same as far as I'm tracking and understanding. It's part of it, like I said, was the concern early on about Miss Agnew not honoring the 7 daily ones until it tapered down. If this would have been handled closer to 3 months ago when this originally started, I think we could have better hashed out what that looks like. However, that transition down is no longer relevant at this point, which is why I didn't touch on it. It's over with. It's done. We're down to 4. And so I'm getting the 4. However, the important part is the engaging conversation with the children, so that way they don't find the conversations and the phone times to be a burden. The children at times do indicate that they are kind of tired and burnt out with the phone calls. And we had a conversation about that, Your Honor, where you and I had talked about it and said, hey, sometimes they're not going to want to talk for the full 15 minutes. And I acquiesced and I understood that. But part of that key is having something engaging. And if we would have access to the Skype and to the Zoom, like it was set up and like it should be, then it would be a lot more engaging for the children to have those conversations, and they wouldn't feel so cumbersome by those conversations. And it would benefit them much more greatly if we were using the device that was ordered to be using to facilitate those discussions. And nothing further, Your Honor.
Before you cross, Mr. Ikenberry, let me ask a couple questions. Right now, you're having the 4 phone calls. What device is being utilized at this time?
Mr. Bear's phone is my understanding of what device is being used at this time.
And are you able to do any video callings?
Yes, we are. There was an issue about 2 weeks ago where Meta was having issues, and so we were not able to facilitate that phone call during that day, which is another great example of why having the different options of Skype and Zoom to be able to facilitate those calls were so vital.
And have you been able to utilize the Nintendo Switch, play games with the boys?
I have not. The children are able to use the device because it's just a handheld device. If you wanted to make it that way, However, there's no connection between the children and I. And so I have not been, I've been able to use mine, they've been able to use theirs. We have not been able to connect together, which is what the promise was from Ms. Agnew and the promise that I made to the children.
Okay. Mr. Ikenberry, go ahead and do your cross.
Your Honor. I would like to try to attempt to share the pretrial order.
Go
Do you
ahead.
have access to that, Your Honor?
I do not, unless Jess can get that hooked up for me. But if you share it, I'll see it.
At the top of it, Mr. Agnew, it says the 23rd of September, correct?
It does.
And can you please pinpoint for me where it says a particular device must be used for your phone visits?
I need a moment, Your Honor.
The item regarding the phone is number 4.
So this is a nunc pro tunc. It has been edited because there were issues with the original one. That is a good indication that there may be other issues with this one as well. If you would like, we could get into the transcript and we can go from there. I have not gotten a copy of that because I believe that that is something that the judge is very clear about. However, if I need to, we can adjourn this and I can get the transcript and I'd be willing to pay for that. And then I can show you in the transcript where that was ordered.
The whole thing is based on you thinking that a particular device has to be used for you to have communication with your children. Isn't that true?
That was the judge's orders, yes.
No more questions, Your Honor.
Mr. Agnew, do you have any other witnesses regarding your motion?
No, Your Honor.
Okay. Mr. Ikenberry, do you have any witnesses regarding the motion?
Your Honor, I'm going to have Ms. Agnew testify briefly.
And you can stop sharing on that document, Mr. Ikenberry.
Thank you, Judge.
You solemnly swear and or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
I swear.
And you're in Bulgaria at this time?
Yes, sir. Yes, Your Honor.
Are you subjecting yourself to the jurisdiction of the state of Kansas for the purposes of this hearing?
Yes.
Thank you. Go ahead, Mr. Ikenberry.
Thank you, Your Honor. Ms. Agnew, were you able to hear the statements made by Mr. Agnew in his testimony and under cross?
Yes.
Okay. Is there an issue with a particular cell phone as you understand it?
Sorry, say that again.
Is there some issue with a particular cell phone as being alleged by Mr. Agnew?
The cell phone that Mr. Agnew had given to us, he deactivated the service and he had parental locks on it. So in order to make it usable, we attempted to reset it so we could get service for it, but that didn't work. So we can't use it. It's just sitting in the cabinet like it did for the last few years. Like we were trying to appease him and it's just sitting in the cabinet like it did since the day he gave it to us.
You believe that you were violating any court orders by using the cell phone that doesn't work?
No, he's still getting all his calls. So no.
So you are making sure that he is having contact with his kids as well?
Yeah, I mean, we still allow for 7 days a week calls. He knows that. He had told us that he was only going to take 4 specific calls. But he's still allowed to take calls 7 days a week. He just doesn't.
So you're offering him more than he's accepting?
Yes.
He testified about some problems on or about the week of February 3 to 5, somewhere in there. Can you explain if there was any issue there? What happened?
So my phone broke on like February 3rd. We then messaged Roger on his Facebook through my husband's Facebook. He didn't respond for a couple days, so I reached out to my mom and had her call him, and then he started responding to Bo's Facebook. The only reason I can see why he didn't respond to that Facebook message when he got it was because he
Some
was
speculation?
blocked.
Sustained.
But yeah, no, we reached out and he has made he's gotten all the calls except for the weeks where he didn't elect to make all 4 calls. When he elected to have Wednesday, Friday, Saturday, Sunday, there have been a couple weeks where he didn't call on Wednesday or he didn't call on Wednesday and Friday. We always message him, offer him additional calls. Sometimes he took it to make it up, sometimes he didn't. There's been about 2 weeks where he only got 3 calls. He didn't make all the calls. He has the opportunity to call every single day though. He just doesn't.
So testimony is he may have missed some visits in that February 3rd window because of
That
the.
week, he didn't miss any visits at all. He still got all 4 calls that week.
So didn't miss any visits along the way?
Not until recently. Recently, after he told us he was only taking 4 calls a week, in specifics, later in the week, he didn't take all those calls, which we asked him to take more, but he didn't. So there are like 2 or 3 weeks where he only had 3 calls.
So your understanding of his motion in contempt is that he's stating a prior court order says this cell phone must be used.
I didn't see that anywhere, and it doesn't make any sense that one phone would need to be maintaining one device for the next 12 years. He cut service. We're in a different country, like that. He's getting his calls. It says nothing about a specific device. I would understand if he's not getting his calls, but he is his calls and he has the opportunity to call every single day. If anyone's in contempt for this, it's him because he's not making those 4 calls. He's not calling every day, let alone the 4 calls.
I was asking him about conversations you had regarding your home internet. Are there any issues with your home internet connecting to any device?
It's not my internet, it's my landlord's internet. It's part of the package. She has rules just like any landlord would when using their internet. And unfortunately, with these parental control locks that only Roger has access to, and I cannot connect anything because he has sole ownership over all of it. Even though he physically handed them to me, he's locked me out. We're both parents. I should at least have access. And that way I could connect things to the internet. I could do what I need to do. I can't do that if I have no access to anything. And like I said, I didn't use this phone the whole time. So how would I know what kind of locks or things he had on it? Because for the years that we had this phone, just like I testified previously, it sat in the cabinet because I'm not comfortable with my children who are 3, 4, 5, 6, 7, all through these ages. It's too young to have a smartphone. It's too young to be connected to the internet in many ways. So that's why I hadn't brought it up previously. It's because that never changed.
Yeah, so testimony at trial was that phone wasn't even used way prior to our trial.
Yeah, never. I'd never. After trial, yeah, we used the phone for the calls until we moved to Bulgaria and we couldn't switch it to try and be nice. But previous to trial, I didn't use that phone. I started using it to try and be nice and bridge a gap. try to stop more attacks from happening.
Your understanding, were you ever ordered to use a particular phone for visitation for Roger?
No, not by the court. No, by Roger, but not by the court.
Those are all my questions, Your Honor.
Cross-examination, Mr. Agnew.
Agnew, the cellular device in question, does it have Wi-Fi capabilities?
I assume so. It's a smartphone.
And so with Wi-Fi capabilities, you don't have to have an actual data plan with a cell phone provider. Is that correct?
If you want to no, I guess not. You don't have to connect it to a provider, a service provider.
You can still use that device if it's only connected to Wi-Fi, correct?
If it's connected to Wi-Fi.
Correct. Ms. Agnew, have you ever had a Facebook message sent to spam that you received?
I don't know. I don't use Facebook often. I can't confidently say. I don't use Messenger often, usually just to call you or my mom.
Have you ever opened up your Facebook spam?
Maybe, I'm not sure. I can't recall a specific instance and when I needed it, which I needed to. So I can't give you any examples.
Second, you testified that when your phone was damaged, you sent a message using your husband's Facebook account. Is that correct?
Yeah, we sent a message on my husband's Facebook account to your account. Yeah.
Why did you not sign into your account to send the message?
Because my Facebook account was locked to my phone. And when my phone broke, I couldn't gain access. I'm in Europe with a different phone number. So it quite literally locked me out of all of my accounts. Every single account I have ever owned previous to living here in Bulgaria, I have no access to. My emails, my previous Facebook, my YouTubes, my Netflix, my Disney Plus, nothing. I have access to nothing. None of them were logged in on my husband's account. There's no access to any of them.
You testified that the first week of February, there were no missed phone calls. Is that correct?
I don't know if that's what I testified. I think what I was saying is that I didn't miss your calls. That you made all of your calls, you received all of your calls up through that week. You got your 4 calls and you had the opportunity to call every day, and we notified you the day my phone broke and gave you alternative ways to contact us.
So in the first week of February, I made 7 phone calls to the boys.
I don't know if you did, but you had the ability to. You were able to call 7 days a week. Whether or not you did, I don't recall, but you had the ability to.
So when on February 3rd did I call the boys?
You didn't, because you didn't see our message.
When
Or
on
you
February,
did, but
when
I
on
don't
February
know. I don't know, because I don't have a call.
Please let me finish the question. When on February 4th did I call the boys?
Like I said, I don't know. I was locked out of my account, so I don't know.
When on February 5th did I call the boys?
I don't know.
Do you recall me talking to the boys and hearing my voice on February 3rd?
I don't recall. That was months ago.
Do you remember on February 4th, me talking to the boys and hearing my voice.
I don't recall.
So as it stands here, you cannot positively identify that I got all 7 phone calls the week of February 4th, or the first week of February, correct?
You got at least 4 calls that week. That's what I was saying. I don't know if you made 7 calls, but I know you got at least 4. We reached out to ensure it.
When was that message that you reached out to me? When was that read?
I don't know when you read it, but because you didn't read it for a couple days, I had my mom call you.
So you know for a fact that it wasn't until Thursday, the day that you called your mom, that I had not opened that message, correct?
I can't help that you didn't open a message.
I'm not asking what you can help. I'm asking, you know for a fact that it was not seen until Thursday, that message, correct?
I don't know when you opened it. I know that you found out. I don't know when you opened it. When did you open it? Show me.
I'm asking you questions. So on Thursday, you called your mom, correct?
Correct.
Why did you call your mom?
Because you hadn't answered our message yet.
So on Thursday, you had seen that message had not been opened, correct?
You hadn't responded yet. I don't know if I can see read receipts, but you didn't message us back. You didn't reach back out. So because I didn't hear from you, I had my mom call you.
On Facebook Messenger, it shows a little chat bubble if a message has been read, correct?
I didn't realize. Sure. Okay. I didn't know. Okay.
Did you see a chat bubble on that one?
I don't recall.
Okay. You testified that the policy in place at your residency is to factory reset all devices before they're connected to the internet. Is that correct?
That's part of it, I think. All I know is that I need admin access to secure the devices that are connected to my landlord's internet. So one of the ways we do that, I guess, is to reset it. I don't know. I'm not a tech person. All I know is I'm trying to do what my landlord says I have to do to live in her house.
Do you have a copy of that policy?
Not on my person. I don't
Do you
have
have a
one
copy?
here.
Do you have a copy of that policy at all in any of your paperwork?
No, it's just oral. It was explained when we got here.
So it's an oral policy, not a written policy. Is that correct?
Yeah. Same as, hey, you take your trash out. Don't, just the basic run throughs. This is how it works when you live in my house, kind of thing.
At what point did you ask for parental control access?
I'm not sure when exactly I asked for control access. Some point after I realized that there were locks on the phone and locks on the devices and that we needed to connect them and we couldn't.
So would this be January? Would it be February? Would it be March?
I'm not sure.
Was it before the paperwork for the contempt motion was filed? Was it after the paperwork for the contempt motion was filed?
I'm not sure.
But according to you, you did in fact ask for the parental control access. Is that correct?
Yeah, we asked for access. I believe it was linked to your RAYLOP email or the one you set up for the boys. We asked for access to that, so we could get through it, and you said no, something along those lines. But basically, yeah, we asked for it, because of we asked for access to the parental controls, and we weren't allowed. We weren't allowed. So there was nowhere to go from there.
So it's your testimony that you were asking for the parental controls and not just to reset the phone and change the phone provider.
The whole goal for all of that was just to get the admin access taken care of. So I don't really recall every specific. I'm not sure what you're getting at.
So you were just asking for the login information, correct?
I don't recall exactly what words I used or what I asked for.
So you don't recall if you asked for the admin access or if you asked for the parental controls. I'm sorry, strike that. You don't recall if you asked for the parental controls or for the login information.
I don't recall the specific terminology. I asked for access, essentially. Well, however you want to call it, ask for access.
Would you agree with me that admin access or the parental controls, we'll use them interchangeably here, and the login information are two different things?
I don't understand the question.
Okay. Let me ask it this way. What does login information give you?
The ability to log in?
Does it give you complete control of the device?
I don't know.
Does it give you complete control of any account with that password and email information?
I don't know.
Okay. When you ask for parental control access, do you need that login information?
I assume so because it asked for it on the phone. And it asked for those things. You never gave us the codes or the emails or anything you used. You restricted the access. However you want, whatever words you want to use. We asked to have access to the device, to the parental controls, to the device, and you refused. I don't know why we're going back and forth on terminology.
Do you agree that when it came up with the Raylop email, you refused to proceed any further?
No, I don't think I agree that I refuse to go any further when it came up with your email. I
The
think we
original email
asked,
the original email that popped up was the children's email. Is that correct?
I don't recall at this point.
So you don't recall if it was the Raylop or the children's email that came up first, but both did eventually come up. Is that correct?
I'm not sure. It could have been either or both. I don't recall. I said I don't recall if it was the Raylop one or the kids ones or whatever email is attached to it. All I know is it was an email I had no access to.
And what steps did you take to try and find a way to get access to that?
We asked you, we talked to you, we messaged you.
And without saying what I said, because that's hearsay, what was it that you got the impression of as to what would happen?
Mr. Agnew, you're going way out of the realm of the question today, and that is the contempt. Now, I
Okay.
understand that it is advisable if you're able to use the Nintendo Switch. You do understand that if they're going to use any of these devices and get them hooked up in Bulgaria, you're going to have to give them access and control to the devices to do that.
And that's never been a contemptuous part. I've never refused to give them access to any of that. I have no problem adding them into the access thing. They never asked.
Okay, well, hopefully that can be done so that you can engage in gaming with the boys.
Sure.
So work with them to give them whatever access codes they need if you want them to use the devices you sent.
Sure.
Okay,
Understood.
okay. Do you have any other questions regarding the contempt on the phone calls in February?
No, I do not, Your Honor.
Okay. Redirect Mr. Ikenberry.
Very briefly, Ivy, you took measures to reach out to Roger and make sure he was having his phone visits during that very week that he filed this motion, correct?
Correct.
And you are continuing to offer him in excess of what the court order was for his communications with the boys.
Correct.
No further questions, Your Honor.
You have recrossed Mr. Agnew.
No questions, Your Honor.
Okay. Any additional witnesses, Mr. Ikenberry?
No, Your Honor. Thank you.
Do you have any rebuttal witnesses, Mr. Agnew?
Would you allow me to represent myself?
If you want to testify in rebuttal, you may. You're still.
Yes, I would. Yes, I understand. I
Under
would
oath.
like to retestify.
Go ahead.
So during the conversations about the issues with the cellular devices, Ms. Agnew had informed me that she was needing the login information for the children's device. And I had informed her that I had that information and was stored on the device. And I wasn't able to do much in terms of resetting it. But eventually we did get to a point where we found the information for her. That was a long, strenuous process, and eventually it got to the point where I asked her directly what she was doing, and she said she was factory resetting everything in an effort to reset up the phone with cell service. We had a long conversation about that and how that didn't need to be done. The children are only going to be using the cell phone device at the home residency. They're not going to be going outwards anywhere. They can connect it to the Wi-Fi. And Ms. Agnew was not satisfied with that. And again, the impression that I got was Ms. Agnew was using the cellular phone device for personal reasons for either her or her husband, and not for the children. So that was an issue. Eventually, it popped up to where it was asking my information, because as the parental account on the device, it was wanting my login information to make sure that the phone was not stolen. At that point in time, instead of being willing to have a conversation and move forward, Ms. Agnew just threw her hands up in the air and stopped all communications about the device, and just refused to do anything with it because she didn't want to do that. Again, there was opportunities for her and I to have a conversation and to work things out. Ms. Agnew never once asked for the parental control access, which I would have been happy to give her if she would have asked, but she never did. And again, that's information that she could have asked for long ago had she done anything with the device. It's in her household. I have no problems with her being connected. Now, some of that may be more difficult than others because sometimes they don't allow two different emails to be connected to the parental device. So I will look into options that I need to do to make that happen. But there's also an understanding that Ms. Agnew needs to understand that it's not going to change anything if only one person has access to the parental device, the parental controls of it. They still have full access of the device itself and full control of it. But Ms. Agnew was very adamant once it started asking for my email that she was not going to do anything else, and she was just going to throw the phone away. So that was the other part of that concern. The Facebook message that her husband had sent, it went straight to spam. Facebook spam does not notify you on when an email or a message comes into that. the only way for you to know is if you go in and look for it. So when Ms. Agnew's mother called, I was able to go in and see that at that point in time. It wasn't that I was ignoring anything. It was just simply it went into spam, and there was no way for me to get that until that day. That being said, the other issue here is that Ms. Agnew could have communicated with her mother on day one, as opposed to waiting and gone that way. If in fact her devices were so far out of reach that she wasn't able to communicate with anybody about anything. Nothing further, Your Honor.
Cross, Mr. Ikenberry.
Thank you, Your Honor. Mr. Agnew, did you or did you not just testify that nearly 3 months after you filed this motion on February 3rd, there are still things that you need to do to make sure this particular phone works?
No, that is not what I testified to. I said that there were things that I could do to allow her to have some parental access to it as well. However, the device is fully functional as it stands right now, and as it has been this entire time.
There are still things you need to do to give her access to be able to use it.
No, there are things that I would need to do for her to have parental access, not for her to use it. The phone is fully functional and fully usable by her right now. Well, let me clarify that. It would be fully functional and fully working for her right now had she not factory reset it. Now, because she's done that, there's a number of things that her and I have to do together offline outside of this hearing to get back to where it's fully functional and fully usable. However, even without her having access to the parental controls, the phone itself is still fully functional, fully usable. The only difference is whether or not she has parental access or not.
You understand that there were problems moving to Bulgaria and access to the internet, various other things, correct?
I am not aware of that, no.
Okay.
The only problems that I'm aware
Let me
of
just
with moving to
move on.
Bulgaria is...
You answered my question. Let me just move on. There was an
Your
effort.
Honor, I was trying to finish that question. I think I should be
Mr.
able-
Agnew, this is his cross-examination. Please listen to the questions and answer the questions.
Okay.
Yes or no, Mr. Agnew, the effort was made after the communication problem on February 3rd to contact you in another way?
After 4 days.
No, after February 3rd, same day. They sent a Facebook message, was the testimony, correct?
I do not believe that that was a honest attempt at communicating with me. No.
Discovered that that attempt was made February 3rd.
Yes, but I would not classify it as an honest attempt.
No more questions, Your Honor.
Do you have redirect testimony, Mr. Agnew?
Yes, Your Honor. The issues that I'm aware of with Miss Agnew and her moving has all been because she failed to properly secure her visas and her green cards for her and the children prior to her moving to Bulgaria. The only problems that I am aware of with that is all regarding that and nothing regarding with internet issues or anything of the sort. And that's all.
You have sir rebuttal, Mr. Ikenberry.
No, Your Honor.
Okay. Closing, Mr. Agnew.
Yes, Your Honor. I believe that the information here has been very clear. Miss Agnew has has not been using the device as ordered in the September 23rd hearing. She's admitted that she's not using that device and has made a number of claims as to why that is. However, I think they lack standing for valid reasons to not be using that device to do anything with. Her claims that she hasn't been given access, well, she didn't ask for it. And so how am I supposed to give something if it's not asked for it? Status quo for 2 years was me having the parental controls on the devices, and there were no issues. And so, quite simply put, if there's not an issue, I can't foresee that, and I can't just resolve it myself. I have to be informed that there's an issue or that something needs to be changed. And Ms. Agnew is the one for responsible for communicating that, and she in fact did not. She testified that there were not 7 video calls that first week of February. That would have been 3 weeks after the children had moved to Bulgaria. So I do not believe that's a reasonable time frame to say that they were in fact fully settled and not at the obligatory 7. But even if the court were to find that, maybe 3 weeks in, you're not exactly entitled to 7, maybe you're entitled to 6 or to 5. Her testimony was, quite simply put, that she only is aware of 4, and she wasn't even fully aware of that. She was very murky on the situation, which either way is not the court order of what we should be at. So it's very clear that there is some level of contempt here by Ms. Agnew, and I'm going to leave it up to the court to determine how much contempt. I think that there's a lot of contempt, especially in the cellular device field of range, because again, she's very vehemently not using it and refusing to use it, and refusing to find any way to work together to move on to getting it to where it needs to be, and asking the questions that she needs to ask to be able to get those things. Those things aren't being withheld from her. They just haven't been asked for. And so that's a problem on Miss Agnew's end, and so I think that there should be a finding of contempt. The order should indicate that both devices will be used, and that I will gladly turn over and get her access as best I can to both parental control devices, so that way she has parental access as well, and she can monitor the children's parental control access.
Mr. Ikenberry.
Thank you, Your Honor. Mr. Agnew's statement just now is kind of indicative of where we are here. He hasn't even provided parental access details for this phone to be properly used and allowed to be used with the client's internet provider, which is part of her rent, which is not owned by her. This phone wasn't even used prior to our pre-trial hearing. I showed the court the prior order that was entered from September 23rd and file stamped November 15th after the Rule 170 time had passed. So this whole contempt motion is based on an order that's non-existent, for one. The phone hadn't been used. The client testified that she attempted to accommodate Roger by trying to use that phone. She made sure that he had his visits, which is the real reason for the order, which means that she's not in contempt at all. She has gone above and beyond, offering Mr. Agnew more contact than the court ordered. So why are we here? We're here because Mr. Agnew, as he testified, wants to fight. Mr. Agnew represents himself. He doesn't have the cost. It's not costing him anything to do this sort of thing. The day he says it stopped happening, he says February 3rd, he didn't get a call. Guess what? He filed a motion in contempt. And my client did her best to try to reach out to him that very day to make arrangements for the calls to happen. This is a monumental waste of time the court, for my client, honestly, for Mr. Agnew. I would ask the court find that she is not in contempt. She has not violated any court orders. She's gone above and beyond trying to make sure the children continue their relationship with Mr. Agnew.
Any response, Mr. Agnew?
Yes, Your Honor. As usual, Mr. Ikenberry has gotten some information incorrect. The contempt motion was filed on February 3rd, the day before, and was written and sent to him on February 2nd. Mr. Ikenberry presented that it is a retaliatory effect for not getting a call on February 3rd. Unless I've got a time machine that I'm not aware about, that is completely incorrect and disingenuous to the court to argue. The not having the hearing, the phone calls happened after the motion was filed. In terms of the in projunct, quite simply, it must be wrong. We can go get the transcripts. We can have that conversation if we need to. But it was ordered that the children's device was what was to be used starting on the pretrial motion, and was used between the pretrial motion and them moving to Bulgaria. And as such, there's no reason for anyone to believe that was changed or was going to be changed. And so it's just an issue. This is a system that is designed where if you don't speak up for yourself, no one else is going to speak up for you, unless you hire an attorney, which I cannot afford. As stated in the moving papers, it is very clear Ivy's pattern to fail with the court order after being informed numerous times over and over what the court order was, what the rulings were, and what the issues are. Starts all the way back on January 14th and continues on through the 2nd of February when the motion was written. And then it goes on even further after that because her inability to properly communicate in an appropriate manner that there had been issues. And so, Your Honor, this is not a monumental waste of time. This is holding someone accountable for their actions and for their choices. And as unfortunate as that is, it is what it is. There's been other motions which detail other times that Ms. Agnew has in fact been in contempt of court, even if there's not been proceedings for it, in an effort to reconcile differences that I have overlooked. However, at some point in time, you have to stop overlooking those differences and you have to start making the motions to hold somebody responsible for their decisions and their actions. And that is what is happening today. It is not a waste of my time, your time, or the petitioner's time. It is, quite simply put, a disagreement in which Ms. Agnew is unwilling to make any compromises or changes on, and left me with no choice but to say, hey, here's a problem and you need to see it. She is in contempt. She's been in contempt many times. She doesn't deny any of those, and it's a problem.
Check to all these other outlying issues that Greg.
Sustain, Mr. Ikenberry. You don't need to argue the objection. Mr. Agnew, we're only here on the issue of whether she is in contempt for failing to allow the phone calls. That's the only issue right now.
But that's where we're at. We're holding Miss Agnew responsible for her choices, and that's where I will leave it at, Your Honor.
Well, Mr. Agnew, you're taking a hyper-technical view of the court orders from prior to the hearing. Prior to the hearing, there had been issues on her not having access to a phone. You were asked to provide a phone to make sure that was no longer an issue. You did provide the phone. We then had the hearing in November and allowed the children to move to Bulgaria. The court does not recall any orders that you had to use that particular device once you got to Bulgaria. The court wants the communication to happen. The court wants it to happen via video, if at all possible, so that you could see and talk to one another, and that is happening. There was a period of 4 days where it did not happen, but she notified you, and when you did not respond, even took the extra step of having her mother notify you. The fact that you didn't see that Facebook communication, it still shows that she was attempting to notify you that there was a communication issue with the phone. So she is not in contempt of court for directly refusing to follow the court order. She had a technical issue. The phone connection wouldn't work. She sent you a message letting you know that. And then when you didn't respond, she took extra steps to have her mother contact you to make sure you knew, hey, I'm not just not making the phone calls, there's an issue. Okay. That does not equal contempt of court. Contempt of court is when you knowingly and intentionally fail to follow the court orders. If you have an issue that prevents you from following the court order, that is not a contempt of court. Okay, so she is not in contempt of court. Now, I would agree with you on the issue other than the contempt citation that playing the games with your boys would be a good thing, and you two need to work together to get that figured out so that they can utilize the Nintendo Switch that you have provided for them to play the games. Okay. You need to understand that it's the person there where the access to the internet is that's going to have to be able to set things. You're going to have to give her all the information she needs. And frankly, it's a little concerning for the court when you keep saying, well, she hasn't asked for it. Well, don't wait for her to ask for it, volunteer it. Send her an email saying, here's the steps you need to take to make this switch work. Here's what you need to do. Here's the passwords you need. Here's the codes you need. Here's the parental codes. Be proactive in this to make sure that it happens.
Your Honor, all the devices are already set up and ready. The only issue that Ms. Agnew has is that she doesn't have access to the parental controls. That's not preventing the device from working. She has all the other information.
Well, and Mr. Agnew, maybe it is. Is there a reason you don't want to give her parental controls?
As I testified to, Your Honor, I have no problem giving her the parental control access and adding her on there. But it was just that she never asked. But
Okay, well,
what you had stated was
volunteer that
that
information to her.
I'm just saying that you stated that it was an issue because she couldn't use the devices. That's not the correct standing. She's just not got the access, but the devices are all fully functional without that.
Well, do what you can to cooperate with one another to make that happen. I think that would be a good thing with you and the boys. But ultimately, Mr. Agnew, the testimony here today is you have had your phone calls. She's given you access even beyond the 4 a week that you've not opted to take those. She has not knowingly kept you from having phone calls where she took an intentional act to keep you from it. So there is no contempt of court here. Okay. Now, as far as increasing your communication to play games with the boys, do what you need to do to get that switch working. Okay.
Okay.
Okay. Any other issues regarding this, Mr. Ikenberry will take up on your counter motion on the contempt. So,
Your Honor, if I may, I want to revisit the last hearing's order just very briefly. The court ordered Mr. Agnew to make a significant payment, and those were your words, a significant child support payment.
correct.
It was brought out that the last child support payment at all was from March of last year. Now, Mr. Agnew has made a $400 payment very recently, but that is about a third of what we will be asking the court to order as a monthly child support figure, going back to when our original motion was filed. So I would ask the court to direct Mr. Agnew to, again, make a significant payment toward the child support present. And of course, there's going to be a very large sum of arrearage to be dealing with as well.
Mr. Agnew.
Correct. There was, let me just double check my dates here. On April 18th, there was a $400 payment. And then on April 25th, there was a $500 payment. I also received notice that there's a $2,852 payment that was made on February 24th, 2025 from the Department of Treasury. So if the $900 isn't substantial enough, which would be equivalent to what the previous hearing was, or I'm sorry, previous child support amount was, which is double, in a 2-week process of what was normally being paid. Basically, it's the equivalent of a 1-month payment. The previous order being $880. The $2,852 is definitely going to be over double of what Mr. Ikenberry had originally asked of $1,500 at the last hearing, and so therefore we've successfully met that substantial payment, as you say.
Well, Mr. Agnew, and we haven't taken this up today, and we'll take it up at the next hearing, but if you have not been paying the child support, there's going to be a very large arrearage that's going to have to be made up. So you need to start working towards paying that as best you can. We'll take up the particulars of it at the next hearing. But
Understood.
you need to fulfill your obligation to pay your child support. That's not before the court right now. That issue was continued to the next hearing, Mr. Ikenberry. Mr. Agnew, the court fully expects you to pay what you can to get this obligation caught up. And
Yes, Your Honor, and we'll get into those
whether
details.
for not having made your payments at the next hearing. How long do you need to prepare for that hearing, Mr. Agnew?
2 weeks should be sufficient.
Mr. Ikenberry.
We don't want to go much further than that, Judge, with the pending summertime and the very expensive plane tickets. And another thing that I think all parties should be aware of is that these children are minors and they can't fly by themselves. So essentially, this is really going to take 3 tickets to get them back here for Mr. Agnew's previously ordered summertime visits. Let me just throw this out there. There will be an arrearage, probably in the neighborhood of $10,000 at least, even considering what Mr. Agnew has stated. So my client floated the idea to me that Mr. Agnew pay for those tickets and we give him an offset in the arrearage. Since he has not been paying support, financially tight in order to spend upwards of $3,500 for those plane tickets. So that's just something I know we're going to need to be addressing shortly. The longer we wait, the more expensive the tickets are likely to get. So just wanted to preface.
Would you two like to speak about that in a breakout room?
We could, Your Honor, but
Mr. Agnew, are you willing to have that conversation with Mr. Ikenberry in the breakout room?
I can have that conversation.
Okay. Jess, could we put them in a breakout room?
Just Mr. Agnew and Mr. Ikenberry?
All 3 of them.
Okay.
If that's acceptable to you, Mr. Ikenberry.
that's fine, Your Honor.
Okay, because she's probably got some information you'll need to know.
Thank you.
Mr. Ikenberry.
Your Honor, that's something, the issues that I brought up is something that we're going to be speaking about in the very near future. after I spend some more time talking with my client about that. Regarding resetting the next hearing, I'm available the week of the 19th is the Monday. I can't do that day, but Wednesday through Friday, I'm completely open that week, the 21st through the 23rd.
Yes, we need to set the next hearing.
Okay. I'm sorry, where am I looking, Judge?
Well, we need to go at least, or right around 2 weeks out. Mr. Ikenberry is suggesting sometime about 3 weeks out on the 21st, 22nd, 23rd.
You have availability the morning of the 22nd, Judge.
Perfect.
Does that time work for you, Mr. Agnew?
Your Honor, that's not a very good day for me. I do a delivery run out into Garden City in the area, and that's an all-day process for me.
And that week, Judge doesn't have any other availability. If I go back, he has time the morning of the 14th.
Can't do that week, sorry.
Yeah. And then the following week, I don't know if that's getting too far out.
Do you have any time on the 23rd or 24th?
24th is a Saturday, Judge.
Oh, that's not gonna work then. How about on the 23rd?
Well, the 23rd, as far as Miss Agnew's calendar, I don't know that we want to do an afternoon setting with the time change.
I will make anything work.
Start early, what are you, 7 hours ahead?
I'm 8 hours ahead. But if I have to be up at 3 o'clock in the morning, I'll do it.
Well, 1 o'clock would only be 9 for you then.
Yeah.
Wouldn't be quite that bad.
1:30.
Think that'll work, Your Honor.
So May 23rd or 22nd? What day?
22nd, you don't have,
That
you,
doesn't work.
no.
23rd at 1:30?
Yes, Judge.
Same Zoom coordinates?
Yes, Judge.
And Mr. Ikenberry, will you do a journal entry from today?
Well,
One other thing, Your Honor, I have a harassment issue that I'll need to bring up. Would you prefer me just to do a written motion and serve that and to bring up during the next hearing?
Well, you've got to give Mr. Ikenberry sufficient notice so that
Sure,
he can be prepared to deal with the issue.
understood.
You could certainly send him an email first and see if you can resolve the issue. If you can't, then file a motion.
Okay, understood.
Anything else today, Mr. Ikenberry?
no, sir.
Mr. Agnew?
The only other thing, I mentioned it previously at the last hearing, the motion that Ivy filed, I believe needs to be sealed. It contains the children's first names, and ages on there. Generally that stuff is, edited in some way, shape or form. So I think that we need to do that for, privacy reasons, but other than that, no, I would have nothing else.
Right. Jess, can you take care of that? Just need to go back and seal her
Yeah.
counter motion of April 16th.
Judge, that would be something for the clerk. I can't do that.
Okay, Mr. Ikenberry, if you'll put that in your journal entry for the clerk to go ahead and seal that.
Do that, Your Honor.
Okay, anything else?
No, Your Honor.
Okay, thank you all. We will see you then on the 23rd.
Thank you, Your Honor.
Thank you.